Okay, some new documents came out after Hippler's death penalty documents, striking down the motion to remove the death penalty. And I already talked about one of them in a video yesterday, and that was Bill Thompson asking for Jeff Nye to basically remain on the case as a special, as the assistant attorney general, and then allow him to make the decision on appointing another one if there were staffing issues. Well, Ann Taylor is now challenging that. Now, mind you, the Judge Hippler, approved Bill's request. So after he approved Bill's request, Ann filed a challenge. And I'm really puzzled by this one, but we'll take a look. And then we're going to discuss a couple of the other documents that hit the website as well, including one about the Franks motion. Okay, so it says objection to court's order regarding special appointment of special assistant attorneys general and decision without hearing. Comes now, Brian C. Koberger, by and through his attorneys of record, and objects to the amended petition for appointment of special assistant attorneys general, filed November 19th, 2024, and the request for decision without a hearing on same, filed November 20th, 2024. The grounds for this objection are that the state has not articulated good cause for the appointment. Idaho Code does not authorize multiple attorneys general, and Mr. Koberger will be denied the right to a fair trial if the state is given the broad authority to appoint multiple special assistant attorney general without any specification of who and how many. It says Idaho Code 31-2603B states, the prosecuting attorney may petition the district judge of his county for the appointment of a special assistant attorney general to assist in the prosecution of any criminal case pending in the county. And if it appears to the district judge to whom such petition is addressed that good cause appears for granting such petition, the district judge may, with approval of the attorney general, appoint an assistant attorney general to assist in such prosecution. It says the plain language of the statute allows upon the finding of good cause for a assistant attorney general to assist in the prosecution. The state's petition asks to give Idaho's criminal law division of the attorney general's office the broad discretion to appoint as many designees as he sees fit. The authority sought in the proposed court order is that the Deputy Attorney General Jeff Nye and any other Deputy Attorney General selected by the Attorney General's office be appointed as special assistant attorney generals to assist the prosecution of this case. Okay, now I find this interesting considering that he has had two working on the case. So this was back in 2023, April 2023, when Bill petitioned the court for Jeff Nye and Ingrid Beatty. So two assistant attorney generals. And this is when Judge granted both of them to be allowed to work on the case. Now, when Bill did that petition, he cited that exact same Idaho code that Ann is citing. So if she had a problem with two assistant attorney generals being allowed, why did she not do a motion back in April of 2023? Why has she let both Ingrid and Jeff Nye go on helping the prosecution all this time? So over a year, well over a year, because April of 2023 they've been on the case. But now all of a sudden she has an objection to more than one assistant attorney general helping on the case. And also, I don't see anywhere in the motion that Bill filed or in what Judge Hippler said when he granted that Jeff Nye could continue on and that, they could appoint as needed, where it says basically unlimited attorney generals could be appointed. All that was talking about was if any staffing needs arise. So it's not sounding like any more than two would be involved in the case. And again, two have been on it since April of 2023. And I don't quite understand how that's a violation of Koberger's rights, having two assistant attorney generals helping the prosecution. I'm not quite understanding that at all. But Anne is asking for a hearing, and she wants the prosecution to show good cause. And I'm just thinking, this is like a year and a half late. It's just puzzling to me. Now, the second document I wanted to go over was how Bill Thompson had objected to the memorandum for the Franks hearing and the memorandum for the striking of the genetic information because the amount of pages went over the Ada County local rules. And Judge Hippler said he was not going to strike down Anne's memorandums, but there's a little twist. Okay, so it says order denying motion to strike defendant's memoranda. Before the court is the state's motion to strike defendant's memorandum in support of motion to suppress the genetic information and memorandum in support of a Franks hearing. The state aptly points out that both memoranda violate Rule 8.1 of the 4th Judicial District's local rules, setting a 15-page limit on memoranda in support of non-dispositive motions. Defendant's memoranda at issue are 37 pages and 33 pages, respectively. Moreover, defendant did not seek leave of court to file over-length memoranda, which is contemplated by Local Rule 8.3. Given the breadth and significance of the two motions at issue, the court declines to strike the memoranda. Had defendant moved for leave to file over-length briefs, it would have been granted. The court will, however, allow the state an equal number of pages in filing its responses to the two motions. In the future, counsel shall abide by the page limits set by the local rules or seek leave of court in advance of filing an over-length brief. Okay, so instead of striking them down and having her refile, he said he recognized the breadth and, nature of the case, basically. So he's letting it stand, but he's giving the prosecution the same excess amount of pages when they file their response. So he basically leveled the playing field. He's like, well, since I'm not going to strike these down, I'm going to give the prosecution the same overage. And, of course, he reiterated in there at the end, you need to follow the local rules. So that, to me, is saying the next time you do this, you're not going to be so lucky. We're going to strike it down. That's the impression I'm getting from that. Now, the final biggie that just came out was him asking her for her to resubmit her Franks motion. And it's pretty scathing. Judge Hippler doesn't mess around. He doesn't mince words. You can tell he's the type that, pardon the language, is shit or get off the pot. Okay? He doesn't like people playing games, giving him the runaround, wasting his time. And he was not very happy with the Franks motion submission, the motion, to get a Franks hearing. So let's look at this document. Order regarding the Franks motion. Before the court is defendant's motion for Franks hearing and memorandum in support of motion for Franks hearing. Accompanying the motion are 38 exhibits comprising over 2,000 pages. Unfortunately, defendant's memorandum largely fails to identify with particularity the relevant portions of the exhibits, instead referring simply to the exhibit number without identifying the precise pages at issue. Thus, the court is left with the unenviable task of sifting through pages and pages of largely irrelevant documents to ascertain what portion defendant may be referring to. The court is not required to search the record looking for evidence. And that comes from Venable versus Internet Auto Rent and Sales ruling. Consequently, If defendant wants the motion to be considered, he must file a revised memorandum identifying the relevant portions of the record by page number and line number if referring to testimony for the facts asserted. In addition, the defendant must resubmit his supporting exhibits to exclude portions that are not relevant to the motion. Because the state is under a deadline to respond, the court will allow the defendant until Tuesday, November 26, 2024, to submit the revised filings. Hippler did not sound happy at all in that order. So Anne has until the 26th to do a revised motion and memorandum. So it will be interesting to see if she meets that deadline or if she's going to do a motion for leave to see if she can get more time. One thing's for sure, Hippler is not like Judge. He's not going to sit here and let her stall. He's going to be like, nope, get to it. Got a deadline, get to it. So just interesting. Feels like this case has taken a definite different feel since getting moved to Ada County and Judge Hippler. So as always, let me know if there's anything else you want me to go over. Thank you.